Um, and I am excited to welcome you all to All Things Estate Planning. We have Anna Main here from Haskins, Main and Devine with us today to walk us through some of the basics of estate planning. And estate planning is a great thing to do at any age, whether you are younger and haven't had a family yet, or you decided, you decided that you're later in life and you just want to make changes or improvements to your estate plan. It's always a great time to check in on the health of your plan and make some changes if they apply to you. So we're just going to dive right in. And if anybody has questions during the presentation and you're attending remotely, you can use the chat feature on Zoom to add any questions, and we'll try our best to have Anna answer those. I also, before I forget, I wanted to just say that we have lots of our 2026 events getting added to our website right now. So go to our website if you're interested in joining us this year for perhaps a field trip or our thank you party on April 23rd. We would love to see you at some of our events, and you can sign up on our website. And I will pass things over to Anna.
Yeah. Let's here so you can see the chat and then pass this on down. Once I
to Anna?
Down to Anna. Okay.
Yeah. And then I want to make sure.
Hey, so my name's Anna. I'm a partner at Haskins, Main and Devine, which is located in Monona. Primarily, we do estate planning and some elder law. And elder law can mean a lot of different things: probates, guardianships, also Medicaid, long-term care planning. So as I said, if you have any questions, just feel free to add them to the chat, and I'll do my best to answer those as we go along.
See the participants.
Oh, do you see Mary's over there? So there, if you don't know.
And can I just use the keyboard to scroll?
Oh, there we go. Yeah.
You want the mouse?
Or here, I'll give you the mouse here.
Yeah.
How about that? Okay. I think you did it when you did the.
Okay. So I hope to cover several areas today. First is why and when to get started with estate planning. The next is reviewing the fundamentals of estate planning concepts and the basics, as well as how and why to include charitable giving as part of your estate plan, when to get started with the process and what to expect with the process, as well as working with an estate planning attorney and whether at my firm or another firm in the area and working with them would be a good idea. Clearly, I work with a Mac because I'm still learning how to use a mouse. So estate planning and managing the transitioning. So what is estate planning and who is it for? An estate plan provides a legal safety net for 2 points in your lifetime, primarily disability and at death. So we advise thinking about it as managing transitions as well as addressing those 2 major time periods. An estate plan is designed to minimize the reliance on the default state rules when those do exist. And the size of your estate is rarely a factor in why you need to plan. The default rules in the state set forth for you in terms of disability. One of the factors people need to know is we are not a next of kin state. There is some legislation going through the state right now, but it is not in place. So without a power of attorney, you really are relying on the guardianship and courts for who is going to be appointed to make decisions for you in the event you can't make decisions for yourself. And we'll talk about more on that later. And obviously death, we'll talk about estate planning, wills, trusts, things like that. Primarily setting your estate plan and putting it together allows you to determine who, what, when, where, why, and how you want that plan to be put in place. So what exactly is an estate plan? It is made up of many different documents kind of laid out on the screen, wills, trusts, there's many different kinds of trusts, financial powers of attorney and healthcare powers of attorney, an authorization for final disposition, which talks about thoughts about how you want to carry out your funeral planning or cremation planning, and appointing representatives to do that for you, because funeral planning really falls into an interesting place in estate planning, because powers of attorney end at death, and your wills and trusts typically aren't immediately don't immediately have authority for those people to step in without a death certificate. So, and a death certificate is typically done through a funeral home. So it really is a time period that's very interesting. So that form was created for that purpose. Living wills kind of interplay with the healthcare power of attorney. It talks about very specific situations with regard to your health and what decisions you would want to be made in those very specific situations. And it actually allows a doctor or physician to make those choices for you, even without an agent in place. And a marital property agreement, we'll get into marital property law in Wisconsin, but it allows you to opt in or opt out of specific parts of Wisconsin marital property law. So with these documents, one's not necessarily better or more important than the other, but we'll discuss more about what each document does, and then you can decide what kind of is the most important document for you. We obviously encourage you to have all of these in place, but they do each play specific pieces and parts. So we'll kind of talk about some basic concepts in Wisconsin estate planning law and provide a framework for how a will comes into play. So that is talking about specifically what is probate. Probate is the legal court process to transfer assets from one person to another when that one person is deceased, and allow them to transfer the property to their heirs and beneficiaries. Typically, if a deceased person has completed a will, it can be used to legally transfer a person's property according to their terms. And if a deceased person does not have a will, then the probate court may be used to legally transfer a person's property according to the heirs at law in the state of Wisconsin. So that is set forth by statute. Think of kind of your family tree, and the court's job is to find the closest family member that's living and then distribute assets based on kind of that line. And that's laid out again in the statute. So typically it'd be, if you have your spouse, it'd go to your spouse. If you don't have a spouse, then your children. If you don't have children, it kind of goes up family tree and out. With the probate process, the personal representative or executor is supposed to file a will in the county where the person has passed. Then the court appoints that executor, so long as everyone is in agreement. And the court sets a creditor deadline and requires notice to be published, allowing creditors to file claims. After a period of time has passed, the personal representative has kind of gathered the assets, determined what they are, and files an inventory of those assets. And again, this is all public, people can see. And the personal representative then pays all the bills, any final expenses, and then distributes the remaining assets out to the beneficiaries. Many people do want to avoid this process for various reasons. It's fairly costly, it takes a good amount of time, and then there's just that lack of privacy with everything being public record with courts. Nothing is necessarily exempt from this process in terms of the steps, but there are ways to avoid probate, and we'll talk about those through beneficiaries, transferring assets to trust. So another main piece to better understand why Wisconsin laws are the way they are is explaining marital property. So property classification system, marital property is a property classification system that applies by default if you're a resident of the state of Wisconsin and you are married. It may be modified by a marital property agreement. So again, typically you see that as a prenup or an opt-out agreement. As you can see, Wisconsin's kind of an island in marital property. Primarily, it is based on southern states that have more Spanish or French influence. So, Louisiana more French, California more Spanish influence. But Wisconsin adopted their marital property law, I believe, in the 1980s. And that was based on a series of cases, that led to that. I won't get into too much history on case law, but it does allow for compensation earnings on individual property that's commingled with marital property, and very difficult to trace, to be presumed as marital property and be divided equally between the both spouses. Individual property, on the other hand, is property that may be brought into the marriage or inherited by gift, or gifted to you, and that is considered separate. However, again, you really need to avoid mingling it with any marital property, or again, that presumption applies. So this is an important concept because the right of an individual has to distribute or control property depends on if it's marital or individual. And that includes leaving it upon your death or naming beneficiaries. A lot of times someone may name, their children from a prior marriage as beneficiaries in investment account. But if the death certificate shows that you were married, the spouse is entitled to half of that, regardless of what the beneficiaries are on that account, unless you can show you have a marital property agreement. So it is an important concept to understand. So what is a will? So a will allows for the transfer of property upon death when there's no beneficiary designation, TOD, that'd be a transfer on death, or POD, payable on death, on an account. Again, it does require going through probate for that will to go into effect. It also allows for the distribution of tangible personal property, as well as naming guardians for minor children or children with disabilities that have guardianship, or the naming of personal representative or executor. Tangible personal property is probably the most common thing that we use to distribute under a will, or we use a will to distribute. And that could be anything kind of in your house or vehicles, but just not like cash accounts or cash in and of itself. That would not be considered tangible personal property. Wisconsin does require that a will be in writing, and that it be signed in the presence of 2 disinterested witnesses. Most attorneys also notarize a will. So you can't typically handwrite a will and just sign it. That's not considered valid in Wisconsin. But those witnesses are very important, and they can't be like relatives that are named in the will or anyone that is really named in the will. So do you need a will? I think the most important thing to determine whether or not you need a will is really to review the type of property you have and how, without a will, you'd be able to pass that property along. So do you have property that could be subject to probate? Property subject to probate is property that can't be titled or can only be titled in an individual's name. Property not subject to probate would be things like retirement accounts, life insurance, payable on death accounts. So those would be bank accounts that are not in the name of an LLC, or transfer on death accounts, think brokerage, investment accounts, stocks, or a property that's titled jointly. Most commonly that would be, real estate or joint bank accounts. Real estate is often owned as survivorship marital property if you are married, and that would automatically transfer to the spouse upon the first spouse's death. Another way to transfer property is through the use of a marital property agreement. It is typically, this type of marital property agreement is usually done solely for estate planning purposes. Typically, it's considered a post-nup, so done again after the marriage. And it's not necessarily commonly relied upon as a transfer document, but most do include what's called the Washington will provision that would allow you to show it to a bank. Even if an account was in one spouse's name, it would allow that bank to transfer to the other spouse upon a spouse's passing. So it can be useful for more than just determining whether something is marital or individual property. So what are the benefits of a will? We've talked about kind of why you might not need one, but there are potentially benefits as well. So the ability to consider a beneficiary's individual's characteristics, circumstances, or special needs. Many clients have questions about who they should name as personal representatives. So a will can appoint someone if maybe your children don't necessarily agree with each other all the time, and you might want to name a bank or a third party as the decision maker after you pass. It also allows for dispositions to friends or charities, and that the statute does not really consider. They're really just looking at, again, the closest line of family members. And then it enables you to build your own succession plan for management of your estate or distribution of your property. So this would be if you kind of want to leave some to relatives, some to charities. It really allows you to kind of manage that. So we'll talk more about kind of those unique circumstances on why maybe you would want to consider using a will. So if you have a second marriage or children from a prior relationship, again, we want to consider maybe you don't want to leave everything to your spouse. Maybe you want to leave something to your children, something to your spouse. We also want to consider family members with disabilities or special needs that maybe they might lose benefits if they inherit property directly. So we want to set up a trust for them. Maybe, again, you want to give to charity, or you want to leave non-standard distributions. So that would be just a small amount to your children, and then a small amount to friends and relatives, and then anything that, again, is not that standard distribution amount set by law. And finally, I'd say a lot of times our clients come in, they just got married or just are starting to have children. They want to consider their minor children and setting up trusts for them so that they're not going to receive like a large inheritance at 18. So wills are a really good tool for that. So again, hopefully it never comes into play, but hypothetically, if they were to inherit before they turned 18, you could set up trusts for them and pick out the individual who you would want to manage their property. So wills are not the only way to set this up. Another option is a revocable living trust. So a trust is often considered an alternative to a will. It actually holds ownership of your assets. So you would retitle bank accounts or real estate in the name of a trust. And it can be designated as the beneficiary of certain assets. Think life insurance or retirement accounts that may need to be under your ownership during your lifetime, but you can name the trust as a beneficiary. Typically, a joint living trust is done for a married couple, and then an individual could just set up their own revocable living trust. So a trust is created by a settlor, or this could be a grantor. It really just depends on the attorney and what language they want to use for that, but the person putting the actual funds into the trust. During his or her lifetime, they are the beneficiary of that trust. They have control over it. For a revocable trust, it can be amended or revoked at any time during their lifetime. And they are, again, managing it during their lifetime and then choosing successor trustees to manage it after they passed and distribute the assets after either the individual passes or both spouses pass. So why would you use a trust instead of a will? So historically, they have been used for tax planning purposes. This really isn't as common under the current tax rules. The estate tax exemption for an individual federally before they would need to pay estate tax right now is $15 million. For a married couple, that's they get double that, so 30 million. So most people's estates do fall under that, and Wisconsin doesn't have an estate tax. This is very different from what the estate tax rules were 10, 15 years ago. So, and we can't obviously predict what they will be in 5, 10 years. But right now, trusts typically aren't really used for that tax planning as much. Primarily, they are used for privacy. So they can also streamline asset transfers. But since probate is a public process, many people don't want the details of their financial affairs to be public record. So trusts allow you to keep that private. You don't have to do any public filing for inventories or accountings. Trust can also be used to reduce potential conflicts among beneficiaries. There really isn't a time period in which people have the right to object to a trust. So you may have seen clauses in wills before that say, you know, if a beneficiary objects, they lose all right to their inheritance. It's not really necessary in trusts to use that language because, again, there really isn't an objection period like there is for a will in probate. It's also typically faster administratively to use a trust than go through the probate process. There's not necessarily a creditor period like there is in probate. And you're avoiding kind of the deadlines of the court and the restrictions of the court. So it is often faster to administer a trust than in probate. So again, by bypassing probate, you don't have to pay an inventory fee to the court. And you have typically a continuity of management of assets. So if you set up a trust account during your lifetime, you don't have to necessarily close that account and open a new account like you would with probate. So expenses for like homes that are automatically paid out of that account can continue to happen. There isn't a period where expenses couldn't get paid. And once everything is consolidated within that trust, the trustee can work to transfer assets to beneficiaries almost immediately, whereas they don't have to get approval from the court. It can be, again, a tool for managing things during your lifetime, even during incapacity. So if your real estate is owned by a trust, a successor trustee can step in even during your lifetime. If you lose capacity, if your house needs to be sold, or just a management in terms of paying expenses, things like that. Initially, again, the grantor, the person putting the money in, typically serves as trustee. But then you get to pick who you name as successor trustee. So that could be a family member or a corporate trustee. There aren't any tax consequences so long as it's properly set up. Everything is taxed under your social security number typically during your lifetime. And then get what's called the step up in basis at your death for your assets. I won't go too much into tax planning. I'm not an accountant. I always recommend you find a good one if you have any questions, but typically, there aren't many capital gains that are paid by a trust after your death. Now, we don't get away from income taxes, and there are obviously exceptions to this rule, but it usually is a good way to manage assets. And we'll get more into kind of corporate trustees in a little bit, why you may or may not want to use one. But it's just trust can be just a really good, simple way to organize your assets and manage them during and after death. So there are disadvantages to trust, though. They can be a little bit cumbersome to set up. So one of the main things is we want to make sure all your beneficiaries are set up, that certain assets are transferred to the trust. This is a little bit of work on the person setting the trust up. It can't all be done by an attorney. Especially with real estate, we need to transfer that real estate into the name of the trust oftentimes. It requires a lifetime of review as well, because we want to make sure that, you know, if your bank changes hands, changes names, changes systems, that those, if you use beneficiaries, are continued, or that any account you open is opened in the name of the trust. And then it's not necessarily a set it and forget it type of thing. And it can be potentially costly to administer if you use a third party or corporate trustee. I did get a question about trust and protecting assets. So specifically from creditors. I'm not necessarily reviewing what's called an irrevocable trust in this presentation, but that is an option for people. Typically, it's set up to as a Medicaid protection trust. So if you have concerns about paying for long-term care, as long as the assets are within that trust for 5 years, it could be protected from estate recovery under the current rules of Medicaid and estate recovery. In those assets, again, the assets need to be titled in the trust. This is a complicated legal strategy. It's not one I would necessarily recommend for every person. So again, I'm not reviewing it too much in this presentation. And it doesn't necessarily protect from other types of creditors. And there are obviously consequences of retitling assets in the name of irrevocable trusts. Most banks won't give you a mortgage or allow you to refinance with those type of trusts. So just to be clear, revocable trusts don't necessarily protect from creditors, and even irrevocable trusts don't necessarily protect for creditors. So it's not an advantage or a disadvantage necessarily, but I did want to address that question. And then we also had another question about how planning for individuals who own farms is different than planning for non-farm owning individuals. It's not necessarily the farm that makes a difference in estate planning, but rather the goals of the individuals, how they want to pass that farm on, or how anyone wants to pass their assets on to their beneficiaries. So if the goal of passing the farm on is to pass it on to their children who want to continue to farm it, or even want to require that they don't sell it, that's a very different goal from a farmer who maybe doesn't have any children and maybe anticipates that it's going to be sold upon their death. So if, again, planning for individuals with farms or farm owners isn't necessarily, it's not, again, the farm that dictates how your plan is going to be set up. It's really what are your goals for that particular asset. So if they do want to pass it on, oftentimes we recommend that they pass it on in a trust. Potentially an irrevocable trust could be a good idea for individuals with farms, because oftentimes they are asset rich, but not necessarily cash rich. So paying for things like long-term care is a concern, because estate recovery could come back and place a lien on that farm. So if they need Medicaid to pay for long-term care, oftentimes liens can get placed on houses, land, anything that person might own, even if they don't have to sell it to qualify. So it is something we do talk about for individuals who have farms. Also, if they have multiple children and they want to leave it to all of them, perhaps an LLC is a good tool to allow certain buyout provisions. If they want to allow their children to buy another child out for less than fair market value, an LLC can be a great tool for that. So again, it's really about what the goals are in terms of planning for things like that. So what would happen if you don't have a will or a trust? So again, Wisconsin laws by interstate succession do apply. Property is passed to surviving heirs. Again, think about that family tree. It's equal distributions based on the family line that heir is living in. Charities are not included. There's no special needs planning that is set up by state law. And it fails to appoint a specific personal representative or guardian for the minor children. So it's really about who is willing to step up and step into those roles. So I often tell people who are thinking about who they want to be guardians for their children, again, if you don't decide, it's going to be the loudest family member in the room who's willing to play that role. So that's not necessarily what an individual may want. And finding default beneficiaries can be expensive. Oftentimes it requires an heir search that could be a couple $1,000s. And there's been cases, where it's tens to potentially over 100 beneficiaries in a probate. So depending on how close your family members are, how far we have to go down that tree, it could be quite expensive. Okay, so talking more about documents we use during your lifetime. Responsibilities for an individual under a durable power of attorney for finances and property can be quite broad. So this is the document that allows an individual to name an agent to make financial decisions for them in the event of their incapacity. And that would be kind of a springing financial power of attorney, or it could be effective immediately. Oftentimes we draft it effective immediately for spouses. There aren't a lot of corporations that are often willing to step into these roles. So a lot of times it's naming an individual, a relative, a friend, hopefully someone you trust to make financial decisions for you. And again, authority can be quite broad. The state form allows you to kind of pick and choose what authority you're giving that person. So it could also be quite limited. Maybe you just want them to have authority over a single bank account. So you can oftentimes go to the bank and name a power of attorney on that single bank account. Durable just means that it is even effective in the event of incapacity. So if you see that word, that's typically what that means. Most financial power of attorneys are effective immediately. The state form does allow for either, but most are effective immediately. Whereas a healthcare power of attorney, which we'll talk about next, is springing. So it's only in the event of an incapacity. Incapacity can encompass various scenarios. So it could be a mental illness, it could be a physical disability if they can't, sign their name, or it could be, advanced age, dementia, Alzheimer's, or even someone just goes missing. So that's probably the most rare situation, but it is thought about in the statutes. If you can't track someone down for a certain period of time, but you need to make sure bills are paid, that could apply too. So a power of attorney for healthcare is kind of the opposite side of the coin. Again, used only during lifetime. Authority does end at death, but it's a written authorization by the principal enabling another agent to act on someone's behalf with respect to healthcare decisions. It is effective when two physicians step in and determine that individual is incapacitated with regard to healthcare decisions. Oftentimes, if it's done at an attorney's office, you'll also get a HIPAA, so a healthcare information release along with that. And the other document, again, you'll see is a living will, and that's a direction to a physician or agent to withhold or withdraw life-sustaining procedures or feeding tubes if death is considered imminent. What you don't see on this list is a do not resuscitate order that can only be done by a doctor. So attorneys can't do that form. And the activation standard is determined by a physician. It can't be modified within the document. So you don't really see effective immediately healthcare powers of attorney. So kind of going back to estate planning after death. So when do we want to consider charitable giving? So there are a lot of benefits to charitable giving. One is kind of the paying it forward thought. You want to leave money to an organization or that its meanings, its purpose align with what you want. Or perhaps an organization allowed you to do something during your lifetime and you want to leave them funds. Oftentimes there's an emotional feeling or uplift with charitable giving. It creates a culture of collaboration and community involvement even after passing. So a lot of times that's like an endowment or something along those lines, or it's just needed by that recipient more than, a lot of times with my clients, they say, my children don't really need the money. I would rather leave it to a charity. So there are also just tax benefits to charitable giving. So even if we're not necessarily worried about estate tax, there are income tax considerations. So with estates, if they are going to have to pay some sort of income tax, oftentimes that estate can take the income tax deduction or reduce the reportable income to the estate. Giving through the estate plan, again, can provide the estate with an estate tax charitable deduction. So there are ways to give during lifetime as well. So if you are concerned about your estate's, the value of your estate, oftentimes we encourage gifting of appreciated stock during the lifetime or gifting of real estate. However, my biggest caveat with real estate is most charities don't want real estate in the form of its real estate. They just aren't able to hold and manage it. That's not every charity. But my office is dealing with a probate right now where there's real estate and that's the main asset and the charity is the main beneficiary. The charity said, absolutely not. You need to sell that real estate. We would like the value of the estate. So I always say, if you intend to leave real estate to a charity, discuss that with the charity first, make sure they're able and willing to handle it or accept that donation. Otherwise, they do have the right to not accept it at all. The other big one we see is qualified charitable distribution of required minimum distributions. So this is donors who are 70 and a half years old are able to donate up to 108,000 total to one or more charities directly from a taxable IRA. These numbers may have changed slightly. The income tax laws change every year. So if you have any questions about how to do that, again, I can always direct you to your accountant or an accountant to discuss that option. Ways to give in an estate plan. Typically, you are naming them directly in your estate plan to receive a cash amount or a percentage of your estate. Often charities have websites on legacy gifting. The Groundswell Conservancy has a link on their page to ways to give, how to leave, with their legal name, with their tax ID number on it. Most charities do have something like this. We always want to make sure that you're using their legal name. What they may be commonly known as isn't necessarily their legal name. As well as some charities may have state-based organizations or county-based organizations, as well as national organizations. We always just want to make clear about which one we want to give to. Otherwise, you can name them directly as the beneficiary of retirement accounts, of life insurance policies, or again, you can leave them outright distributions of property, whether it's tangible or real estate or otherwise. Again, just always make sure they're able to accept it. So there are some considerations for an estate plan. We want to make sure the roles are coordinated. So when we talk about the healthcare agent, we want to make sure they're able to work with the financial power of attorney. So the healthcare agent may be the one making the decision about where an individual is placed if they have to go to a nursing home. If they don't work well with the financial power of attorney, who's going to sign off on that contract to place them there, we can run into a lot of problems and maybe both are going to have to be removed. So we want to make sure, again, we coordinate those roles. They don't necessarily have to be the same person. We just want to make sure that they work well together, or at least are willing to work together. Good. We want to make sure your estate plan is properly funded so that if you're working with an attorney, that they know what your assets are, so they can direct you in terms of naming beneficiaries or retitling those assets. And then oftentimes we build these beautiful estate plans for clients, and then 2 or 3 years down the road, they decide to update all their beneficiaries, and that maybe like, well, I'll just leave everything to one child and they'll distribute it. Well, if that doesn't match or actually directly contradicts with your plan, it can cause a lot of problems down the road, especially if someone just has a will that says everything to my child equally, naming just one child on all the beneficiary designations, so nothing is going to pass through that will. That can create a lot of problems. And there's potentially tax consequences to that as well. So we want to just make sure, again, the beneficiary designations line up with what the plan actually is. Finally, a letter of instruction can sometimes help. So this isn't necessarily a legal document, but it can provide additional guidance to a trustee. So if you are setting up a special needs trust for an individual with a disability, maybe what it can include what your top priorities for that individual are, what their daily life looks like, what their benefits already provide for, but what they might need an extra on top of what the benefit, like state benefits, might provide for. Or it might also just explain why the plan was set up this way and kind of allow your beneficiaries to understand what your goals of your plan were. So sometimes we don't want to necessarily put things in legal documents. Sometimes a letter on the side just helps with that. So some of the biggest questions we get are kind of how frequently should you review your plan? A lot of times it's every 3 to 5 years. We encourage an individual to at least look at their plan. Doesn't even have to be reviewed with an attorney. Just make sure that who you've named in that document is still who you want. The charities are still what you believe in, those type of things. There could also be changes in applicable law. So that could be tax law. It's probably the one that changes the most. So back in 2020, the Secure Act changed a lot about how we address retirement accounts. So again, that might require an actual review with an attorney to understand all of those changes. And then there's just changes in your life. Did you have more children? Did your children get married? Do you have grandchildren you want to take care of? Has someone passed away? Has someone been diagnosed with a disability or gotten in an accident where we might want to consider something like a special needs trust? Additionally, did you inherit anything major or purchase anything that might need some additional modifications? A lot of times if people set up a trust and then purchase a second house, they don't always purchase that second house in the name of the trust. So we need to do a transfer to the trust for that, something like that. So if your plans are outdated, again, it just might lead to something different than what you intended. Again, or you might end up having to go through a probate even though you have a trust. So we just want to make sure that those plans are reviewed every once in a while. So if you haven't ever done any sort of planning before, or maybe you have, but just want to reassess it, we want to gather again all of those key informations that an attorney might need: assets, debts, incomes, and names, addresses, phone numbers of beneficiaries. We want you to consider who you would appoint in each role. We really can't move forward with drafting these documents until you tell us who you want in each of those spots. So that is a big one. We want you to think about what your goals are and who you want to name as beneficiaries. Do you want to just name your children? Do you want to include charities? Do you want to have specific cash bequests, or do you want just to divide everything up in percentages? There's pros and cons to each, so that can be talked through, but just have a vague idea of what your goals are. And then again, please keep in mind the importance of reviewing things and what your current plan does. And then changes in family dynamics or special needs is another big one. So maybe your children had gotten along, but maybe there was a big blowout a few years ago, and naming them as co-trustees is probably not a good idea. They're not going to work well together anymore. So we may need to update your plan to account for that. And finally, what should you expect with estate planning? Number one, you want your attorney to respond fairly promptly, at least respond to phone calls, schedule meeting. A lot of attorneys are fairly busy this time of year, so you may not get in right away, but you want to at least have a receptionist or an attorney respond to you fairly quickly. And again, they may ask or send out a questionnaire that's going to ask about, financial accounts, the amount in those accounts. That is standard. That is good planning on their part. So don't be surprised by, what many people probably consider invasive questions for someone who you may not have met before. If you're not comfortable filling that out right away without talking to them, that's fine, but don't be surprised by those questions. while you may inquire about how much this is going to cost, they may not be able to give you an exact amount until you meet with them, because the cost of doing just a will versus a will with trust could be different. So they should at least be able to provide you with a range though. And then the attorney, once they've met with you, will likely prepare drafts for you to review independently or with their guidance. And make sure you reach out to them if you see anything that's wrong or you want revised. Because oftentimes once they've scheduled that signing appointment and you're at the signing appointment, that's not going to be the best time for you to make changes. So even if it requires a couple appointments with them, just let them know that you want those revisions. Or if you have questions and don't want to set up a signing, that shouldn't be a problem with them. So I think that's all I have for today. I don't know if there were any questions.
Would you mind passing that down? I'll
Yeah.
make sure we can see everyone.
I have
Oh, go ahead. No, go
I
ahead.
have a couple questions. One is, since retired, it's not clear we'll continue to live in Wisconsin forever. So the documents that are set up, they fit all the state law. What do you do when you move to a different state?
Mhm. So oftentimes, if you've moved to a different estate, an attorney will tell you to review all of your documents with an attorney in that state.
Okay.
So the requirements or even how a healthcare power of attorney looks in Wisconsin is
Mhm.
very different even from Minnesota's version or Illinois' version. And they can't even have different requirements in terms of, do they require witnesses or just a notary? So we want to make sure your documents are going to be valid in every state that you live. So especially if you're a snowbird, we want to make sure you tell that to your attorney so they make sure your documents are going to be valid, even if you're in Florida and have, a health emergency, or Arizona or whatever state you live half the year in, for example. Yeah.
And the second question quickly is, Sarah owns her own LLC.
Mhm.
And so how do you deal with that in a transfer, and then, even though it's
Yeah.
equal marital state, she suddenly should get incapacitated and we need to deal with her business. How does that happen?
Yeah, so that really depends on how that LLC was set up. So if both spouses are managing members,
Well, I am now, but we want to put me back to a passive, a non-managed. Yeah.
and then there's really two ways to handle it outside of that. So passing it on can be done through the LLC document itself,
Okay.
or you can assign it to something like a trust, and then the trust can dictate how that is passed on. So it really does vary depending on the LLC or partnership,
Okay.
or however you set I can't answer that, affirmatively. I would really need to, most attorneys would want to review those documents.
Well, then we're going to be doing that. So, well, thank you.
Yeah.
And then I see Kara had a question. Can you see that, Anna? If a donor leaves a more complex asset to charity, such as real estate, mineral rights, fine art, etc., can the charity accept the gift contingent upon the estate paying for an appraisal of the asset?
Again, I would definitely want you to discuss that with the charity itself. So the appraisal of the asset shouldn't be an issue. But definitely something like mineral rights can be quite complex, and not the easiest asset to sell. So most charities aren't going to want to, again, dependent on the charity, they could be a very unique charity that, deals with mineral rights all the time, but most charities aren't going to want to hold mineral rights year over year. So it would really be contingent on what the charity determines. The appraisal shouldn't be the thing that holds that back. It would really be the charity itself.
You talked about retitling assets in the name of a trust.
Mhm.
I've heard of something called a pour over will. Would that avoid that need?
No, so a pour over will is a will that just says everything to my trust. We typically say that's more of like an insurance policy in the event that something wasn't properly transferred to the trust through retitling or beneficiary designations. So even if you have a trust, you should have a will as well. It's going to be that pour over will in most circumstances. That does not avoid retitling. However, if you don't want to retitle, real estate in Wisconsin, you can do what's called a transfer on death deed. So it would be kind of like putting a beneficiary on a piece of real estate by simplistic way of saying. But some law firms don't retitle real estate. They just say, upon my death, it's going to go to the trust. And so that it really is kind of depending on the attorney you work with and what your biggest concerns are on how they're going to handle the real estate or retitling.
Question. This might be very simple. Because I don't have any of this set up, and hopefully I won't have to look at it for a very long time other than reviewing it.
5 years.
Yeah, looking at it for 5 years. So when I like have my retirement accounts set up and I have to name a beneficiary, if that is a non-heir through blood or marriage of mine, is that kind of phooey, since like things would have to go through probate right now and it would go to like my heirs first, or how would that work until this is set up?
So I'm going to give you a hypothetical, make sure I'm understanding. So if you were in like if you had a long-term partner and you wanted to name him as a beneficiary of your 401k, if you named him as beneficiary of that 401k, then that would not go through probate. It would just go to him directly.
Okay, so it's not like all or nothing through probate.
No. If you have beneficiaries on every one of your assets, you don't own real estate, but you have a 401k, there's a beneficiary there, you have a bank account that's payable on death to that person or jointly owned with someone, and those were your only two assets, you wouldn't need a probate.
Gotcha.
Because everything would pass through beneficiaries.
You designate that right with that financial institution, right?
Correct.
You name the beneficiary, so that carries as much legal weight as a will?
Yes,
or-
that precedes the will. That would,
Okay.
I don't think that's the right word. Comes before the will or probate.
Yeah.
Mhm. So even if you have a will that says everything to my two children,
Yeah.
if all of your beneficiaries are naming someone else, nothing would go to the two children.
Because in Wisconsin with joint property, if one of us dies, the other does not. It does nothing. It's just the one person owns it all instead of half of it.
It depends. Yes.
I mean,
In theory, that is what should happen.
Yeah.
That doesn't necessarily mean you're going to own or avoid probate if everything is titled in one spouse's name. We do often do probates for older deeds that were just titled in the husband's name. The wife was never added. That would still go through probate, but it would go to the spouse.
everything we have is jointly, and your TODs on all our accounts and stuff. So I think we're mostly there. From what you said.
Yes.
So when you talk about the family tree and searching for the heirs, how deep and far does that usually go?
So that would only be, again, if you don't have beneficiaries, if you died in probate without a will, as far as it needs to go. So they
It could
hire,
drag on for years and years searching.
most air search firms are pretty fast. They take, 3 to 6 months, which is pretty fast for court processes. They're able to kind of put together that family tree. There's a lot of information out there.
If no kids, it goes back up to parents. If no parents, then
Grandparents,
uncles, grandparents.
Yep, again, you search for the closest living relative and then stop there. And then if anyone died on that same level, you go down to their living heirs. Is what kind of works. But they search through, birth records, death records, obituaries, cemetery records. They can do it pretty quickly.
And if something's jointly owned, they go on both sides.
So
Yeah.
if
Right, which family?
Yeah.
Yeah.
So if one spouse dies and everything then goes to the other spouse, and then the other spouse dies 3 years later, it's just that other spouse.
What if they both die at once?
The court decides who died first.
Wow.
Really?
Yeah,
Okay.
somebody has to die first.
Oh,
In
So-
a car accident, in a plane crash, in a
Yeah, there's
catastrophic event.
sometimes it requires 2 probates. So but somebody has to die first.
Thank goodness for wills.
Would there be, like in the case of, so for example, we have a will and let's say we were to both pass and our child who is now 18 and older, is going to inherit the house and everything. But it's a will, so it would go through probate.
Mhm.
And is there a reason then to do a trust so that it goes faster and the child can like be in the home and be accessing accounts and money and funds and everything and isn't waiting 6 months to a year to have access to all of those things? Like, would that be a good reason to do a trust versus just rely on a will?
So they're older than 18
They're older than 18?
and you aren't comfortable with them inheriting things outright.
And we are comfortable with them inheriting things, but just wanting to make sure that, right, they don't have to wait for everything to go through probate for a year. And in the meantime, everything's just kind of up in the air with all of your assets, right?
If you just have one child, there are ways to avoid the need for a trust.
Okay.
But you could do a trust, it would be faster.
Mhm.
Or you could just rely upon beneficiary designation. So
Okay.
make sure they're designated on all your bank accounts,
Right.
life insurance, retirement accounts, and then do that transfer on death deed for the real estate. So leave them the
Okay.
house directly.
Okay.
Again, that doesn't really account for if they have a disability or anything like that, but that is a way to avoid the need for the trust, but also get it to them faster and avoid probate.
Mhm.
It sounds like once the trust is set up, which is a little bit complicated, but once it's set up, it's cleaner and simpler to do the transfer. Because everything's all together collected in this one place. Is that how it works in reality?
Oftentimes, yes. There's always exceptions.
I'll say, Sarah, that my parents attended one of these sessions one year, and then they went and did a trust, and they did it probably within about a year's time period. So I know you don't know my parents, but I'll vouch for them and say if they can do it, and they can do it within a year's time period,
Okay.
somebody else should probably be able to do it as well.
Okay.
I mean,
And I mean that in the best
Yeah,
way
yeah,
possible.
thanks.
one of your first slides was talking about things that usually don't go through probate,
Mhm,
which include things that are titled and, and things that would go through a will,
mhm.
such as the designations of your property and like I say, and all, at least we were told in all our financial accounts with the transfer and death. And the name, our kids named as to the transfer, that gives them immediate,
Mhm.
almost instant access to those funds and things. So,
Sure.
makes sort of the trust to me seem almost a little too complicated for our situation.
Mhm. Could be,
Have to
right?
figure it out.
Could be.
Yeah,
Yeah.
it really depends on the facts. So
Yeah.
Mhm.
again,
Sure.
if kids work
Mhm.
together, things like
Yeah.
that, if they're
Mhm.
adults.
Mhm.
Yeah, my husband and I, we ended up setting up a trust. And it was very easy once we found an attorney to have the conversation about which option is the best for us. And within a few meetings, we were able to set everything up and have it ready to go. And they even helped update some of the, beneficiaries or whatever. Changed it from individuals to the trust and everything. So yeah, it was easier than I was expecting.
Good. I mean, this is a nice presentation to see the options
Yeah.
that are out there, but yeah, definitely that's why we're here, is because it's time.
Right.
Is there a hand up on the screen or is
Well, it
that
looks
just the
like it.
cursor?
Maybe? I can't tell.
It might have just been the cursor
Oh,
hand.
Yeah.
okay.
Yeah.
Does,
All right.
does anybody on the screen have any questions?
You can ask in the chat, or at this point, you can unmute yourself too if you like.
And maybe while we wait for that, one thing I'll just add is somebody, one other time, someone was talking about how being mindful about what you leave to a beneficiary versus what you leave to a charity, for example, from a tax, like where there could be tax benefits there, both for you and for your children, for example. I don't know if you want to say something about that, but I heard some people when that was shared found that very interesting, right? Like as far as receiving something and then the child that increasing their income, having to pay taxes on that versus something going to them and giving something else to the charity because it can be given to the charity and they're not paying taxes on that?
Yes, so that is definitely a conversation we have with individuals who want to leave things to charities. Looking at their assets, especially if they have pre-tax accounts, IRAs, 401ks. That is often where we look to leave a portion of that or all of that to the charity and then give the assets that don't create that income tax necessarily
Right.
to the children.
Right.
And sometimes that's through beneficiary designation, sometimes that's through a trust.
Right.
It really depends. Again,
No.
there were some changes to the laws in 2020, so we have to be pretty careful about how we do it, but that definitely is something we talk with individuals about who want to leave things to charities. What is the best tax way to do that as well?
Kara has her hand up.
Okay.
Yeah,
Yep. I was just wanting to follow up on the question that I asked previously in the chat and kind of elaborate on that a little bit. So I could imagine that a donor would like to donate a complex asset for exactly the same reason as the charity might hesitate to receive it, in precisely because it's complicated. And if someone is kind of, reaching their golden years and they'd rather travel. They don't want to spend a lot of time getting an appraisal for a piece of fine art or figuring out how to sell it or find a dealer or something like that. From the charity's perspective, which is sort of where I sit, I'm wondering if there's some middle ground between, no, that's complicated, we won't accept it, and yes, we'll accept it even if we don't know the value. And so that's where I'm trying to figure out, like, what's the middle ground? We probably couldn't accept something without an appraisal, but we'd be willing to go through the rigmarole of finding a buyer for a complex asset, provided that we have a general estimate of what the value is. So I'm just wondering, from your experience, like, how does that play out? Is there some way that a charity can take on the burden of finding a buyer for a complex asset when maybe a donor doesn't want to go through that rigmarole, but also knowing that we can't spend more money than the asset is worth?
I mean, as long as the charity says they are fine with it, we don't have any problems doing it. I just always tell an individual, there is a chance that you say, I want to leave this asset to this particular charity, and they have the right to not accept it. And that's usually where we run into issues post-death. So I always just encourage people to have that conversation. Estate-wise or trust administration-wise, there's not an issue with it. It doesn't even necessarily have to have a value, though there is some tax benefit to knowing what the value is if it's a specific bequest. So if we just say this piece of art goes to this charity, we don't necessarily need to know the appraised value for the trust administration outside of the benefit that leaving that asset tax-wise could add
Right.
to trust.
But the charity probably needs to know the value before they're willing to accept it. And so what I'm wondering is, are the only answers that the charity can give yes or no? Or is there a possibility of the charity saying, yes, we are happy to fulfill the donor's wishes, but we need the estate to pay for the appraisal?
The issue with that would be the other beneficiaries are taking on the burden of the appraisal and potentially not seeing any benefit of that appraisal. But if that is written into the trust that has to happen and the trust has to pay for it, or the estate has to pay for it, that require it could be allowable.
Kara, I'll just say too that there were a couple of donors who had reached out to us about leaving us their estate. We're actually working with someone right now who actually, while they're living is having their estate appraised so that we can be informed of that value.
Mm-hmm.
So
Yeah, especially if it involves real estate, that would be so helpful.
Right. So I
Mhm.
think that's what, and we did some talking too with UW Alumni Foundation, right? Because they deal with this sort of thing a lot. Like they have their own real estate department. And that was their one main recommendation was to get to work with the person in particular ahead of time to have the appraisal and to have inspections and all of that stuff done ahead of time so that that person is not leaving you something in their will or trust that hasn't already been through the vetting process.
Mhm.
And working with UW, they have full agreements they require donors to sign oftentimes, but around the same time we are drafting
Right.
the donations.
Right.
So they have a lot of terms that we try to incorporate within our trust,
Right.
and requirements to even leave them anything. So, that is always good to know from the attorney's perspective as well. Are you allowed to leave it to a specific fund, or do we need to leave it to the general fund? There's a lot of terms that are good to know on our side for drafting, because we want to make it as easy as possible
Right.
for the trustee to administer it as well.
Right.
Question.
Thank you. I appreciate it.
Yeah. The question from Angela, would it be safe to say that a donor should talk with the charity first before making the donation?
Yes.
Sounds like, yeah,
Yes.
Yeah.
it's always best case scenario.
Mhm.
Right.
Yeah, but Kara's asking a great question about
Yeah.
what happens if you don't get a chance to talk.
Right.
Yeah.
All right. Great question, Angela. Thanks
Yeah.
for asking.
One of your slides mentioned the tax benefits of making a donation from a taxable IRA, so like a traditional IRA. There are
Mhm.
no tax benefits to making donations from like a Roth IRA?
Yes, because the Roth, the tax has already been paid on it. So there really isn't a lot of benefits to leave it to a charity versus any other post-tax assets.
Got it. Okay. So if you die, you pass, and there's still money in your Roth IRA, for example,
Mhm.
it's not gonna confer any kind of tax benefit
No.
whatsoever. It's just a donation.
Right.
Okay.
Maybe just a little off the wall question. I mean, both of our children are adult, none of them live in Wisconsin. So are there any particular issues with having a will and trust set up in Wisconsin when the payout upon our death is going to go to somebody in a different state who may have different kinds of estate tax ideas or stuff like that?
No issue with setting, I mean, you need to set it
Yeah,
up
I mean,
where
yeah.
you intend to pass away, I guess is the best way to
Yeah.
say it, hypothetically. Or at least you are a resident of, so tax-wise, obviously, we can't plan for where your children might live. Obviously, if they live in a state that doesn't have income tax, that doesn't get them away from paying federal income tax.
No, but they may be saying a state that has an estate tax where Wisconsin does not. So then they might.
The estate tax is on the decedent's estate. So as
Oh.
long as you live in a state or a resident of a state that does not have estate tax, you don't need to worry about an estate tax
Okay.
there. Or there isn't any tax within the United States on receiving an inheritance. There are issues potentially with leaving something to someone who lives in certain other countries. That's a whole other discussion.
But the idea is they're taking it from us before
Right.
we give it to the recipients.
There is an issue with making them personal representatives. So if they have to go through probate, they likely need to pay a bond. If they don't live in Wisconsin, that's not the case for trustees. But if they do have to go through probate, they may need to pay a bond.
Any other last questions on the screen? Terry, Glenn? Great, sounds like we've.
Thank you very much.
Yeah.
Yeah, thanks, Anna.
Thank you. Yeah, and we'll have we'll be sending a reporting out to everybody too with with slides as well. So people can watch for that. And if anybody has any particular questions about making an estate gift to Groundswell, they can direct those inquiries to me and be happy to answer any questions. And hope everybody has a great rest of their week.
Yeah.
Thank you.
Thank you.
Thank you.
Yeah.